Please be seated. The court is now back in session. For the remainders of today's proceeding, the Chamber will hear the observation by parties in relation to the upcoming hearing, taking into consideration the state of health of Mr. Ieng Sari, who is being hospitalized at the Khmer Soviet Hospital, and he is being in the intensive care unit. This is in accordance with the report by the medical doctor attended to Mr. Ieng Sari on the 21st of September 2012, and the recent report in relation to the result of the treatment of Mr. Ieng Sari. Mr. Ieng Sari, report number 642, dated the 28th of September 2012. And that is the purpose of the hearing for the remainder of the day. And once we conclude this oral submission by the parties, the Chamber will proceed to reading the relevant paragraph of case 002/01. And we need to advise parties as well as members of the public of the relevant facts in the closing orders before we summon the witnesses to testify before this court. And Mr. Ieng Sari has expressly waived his right not to be present directly in the testimony of certain witnesses. Now I would like to ask the defense teams, particularly the defense team for Mr. Ieng Sari, can you advise the court as to how much time do you envisage you need in order to raise this observation in relation to the upcoming proceedings?
Thank you, Mr. President. I assume that you were speaking about the proceedings today. But I'm a little unclear. I need about 5 minutes to make my case today, if that's what I'm being asked of. Maybe not even 5 minutes.
The President, thank you. On this particular issue, Judge Civil Cartwright advised the party already before the conclusion of yesterday's hearing. I handed over to Judge Civil Cartwright to advise parties in relation to the oral submission by parties. And now the time is appropriate for parties to raise such observation. And to make it even clearer, I would like to hand over to Judge Civil Cartwright to further clarify this point before you raise your observation in relation to the issue I have just mentioned. I now hand over to Judge Cartwright.
Thank you, President. Just to repeat and expand on what the trial chamber through me indicated yesterday, the trial chamber anticipates that there will be significant delays in proceeding until Ieng Sari's health status is clarified. And as I indicated yesterday, the trial chamber has already sought the expert opinion of Professor Campbell, who was the last independent expert to examine Ieng Sari before he became ill. We have forwarded to him the scan and the report on the scan, other medical information, relevant medical information, and the weekly medical updates, and anticipate getting some indication from Professor Campbell shortly on what steps the trial chamber should now take in relation to getting more concrete information concerning the diagnosis and prognosis. That being so, as I said, we anticipate some ongoing delays until this process is concluded. What we need today is some discussion from Council on how we might proceed during this period while we await a definitive diagnosis and prognosis. As I indicated yesterday, the trial chamber is grateful to the Yengsari team for its indications of waivers for particular witnesses, and it notes that after consultation between the Yengsari team and the prosecutors, further names for upcoming groups of witnesses have been added. However, I think it needs emphasising that it is for the trial chamber to determine which witnesses will be heard, what order they will be heard in, and it's not a very helpful step to take in indicating that parts of a witness will be acceptable but not other parts of the witness's testimony. So we would like some comment on that issue, including comment on the upcoming document hearing and whether Yengsari wishes to participate while that hearing is conducted. This is simply to plan our time as expeditiously as we can, given that there is going to be inevitably some delays while we regroup over Yengsari's health. So having said that, Mr. Karnavas, I think you're ready to address us, and I know that the President wanted to indicate that one counsel only from each team, please. Thank you very much.
Thank you for that clarification. And normally one counsel from the Yengsari team does speak on issues. As you well know, Your Honors, today we submitted an additional list of about close to 15 names, I believe. It is obviously up to you to decide which of those individuals will be coming and in which order. Plus the other witnesses that we already have, we agreed to, or Mr. Yengsari agreed to, because we don't agree for him. So approximately 20 witnesses. We do note and appreciate that everybody has understood our position with respect to an incident that came up with where we did waive, and then it would appear that we withdrew the waiver. And I have had a chance to speak with the prosecution on this, and we're going to hear more from them because I believe that we have found a way to go forward. Our main concern was where we agreed to a witness based on having looked at the available information that we believe is going to come from the witness, the documents that they will show him, and what's in the case file. Then something comes up that was unanticipated, that puts us in a very vulnerable position, because I've given advice to the client as Mr. Angodom, and he's given us his waiver, and now I don't want to act without consulting him or putting him in some sort of a jeopardy. I don't think that we're going to have those problems. There may be instances where Ms. Yengsari's name or involvement, alleged involvement, may be coming up that wasn't anticipated. I think that the prosecution will address that more concretely based on our conversations, but I think we will be able to work around those areas, and if necessary, the prosecution has indicated that we could call the witness back for a very discrete issue, although again, I don't see that being the problem. As far as documents are concerned, We have consulted with Mr. Ingsari, and he's given us his full authorization to go forward on that. So I can reasonably say that with some pre-planning, there should not be any delays in the immediate future. I think we can go forward for the next couple of months. And certainly, just for this last list of witnesses, we made 4 separate trips to the hospital to walk Mr. Ingsari over them, made sure that he was comfortable with what he was doing, and only upon that time, as you noticed yesterday, Mr. Angodom left early, and that was for purposes of getting the waiver. That was the 4th conference that we had on those names. So we appreciate everybody's indulgence and understanding, and I believe that we are making all efforts not to delay the proceedings, because we do have a lot of work that we can do without any delays. Thank you.
The President, thank you, Council. How about the other 2 teams? Do you have any observation to make in relation to this issue? You may proceed.
Thank you, Mr. President. Very briefly, Judge Cartwright had noted yesterday that we were indeed endorsing the position of Ingsari when the defense team said that in regard to new documents produced by the prosecutor, as far as his client was concerned, it was normal that the waiver be lifted, and that it is important for each accused person to be present during the proceedings and to be confronted during the proceedings, and in order to be able to assist his defense team with regard to examination of witnesses. This said, it is obvious that Mr. Ingsari himself is the person best placed to know when he should be present or not during the hearing of his witnesses. And it is in this regard that we endorsed Mr. Ingsari's request. We would like to recall the major principles involved, because we have already had occasion to raise the issue during similar problems. We are a defense counsel, and we may one day find ourselves in the same situation as our learned colleague for Ingsari, and these principles must always be applied. It is important to raise one point today, and may I point out that in response to the request made by the co-prosecutor regarding TCW 386, it is with regard to our motion. I point out that we were opposed to the tendering of this document into evidence. We maintain our request, even though Ingsari's defense has pointed out that insofar as we do not use that document or use parts that concern his client, there would be no problem with hearing the witness. Whatever may be the case, the response that we made in E233/2 remains the same regarding the hearing of witnesses. I wanted to point this out today for the record.
The President, thank you. How about the defense team for Mr. Nguyen Chie? If you have any observation to make, you may proceed.
Thank you, Mr. President. We can be even more brief. We fully support the position by our colleagues for the Ingsari defense team. We have nothing further to add at this stage. Perhaps after the prosecution has spoken, we may want to make some additional comments, but for now, we have nothing to add.
President, thank you. Now I hand over to the prosecution. Do you have any observation in relation to the subject matter of the discussion now. You may proceed.
Thank you, Mr. President, Your Honours, Counsel and everyone before the Court. I think the issue of significant delays, of course, is a concern for the prosecution, and I think all the parties, as well as the trial chamber. And certainly, Judge Cartwright was quite correct. Certainly as of last week, the situation presented itself where it was quite possible in the near future that there may be some delays if Yang Sari's health didn't improve, and at the same time, depending on what Yang Sari himself thought of hearing witnesses that didn't directly provide evidence against his act and conduct, and hearing those witnesses with the waiver. As Your Honours are aware, that the situation between last week and this week has changed. A proposal was put forward to the Chamber and to the defence to look at a number of prosecution witnesses in which, if the Chamber accepted to be witnesses before this trial in relation to the first forced movement and the second forced movement, if waivers were given in relation to those witnesses, certainly there would be a substantial period of time in which evidence could proceed forward whilst the court was determining the prognosis of the health of Yang Sari. I think it's fairly clear that his health, up until recently, he's been fit to appear before this court, and because of the recent downturn in his wellness, as Your Honours have indicated and instructed, it's important that expert reports, or certainly expertise, be obtained to determine what really is the diagnosis and the prognosis for Mr. Yang Sari. So, whilst this is occurring, it's unclear, as Your Honours have noted, that whether he improves within a week or 2 weeks, or whether it's a condition that sort of lasts a lot longer. And until such time that this information has been to be obtained, we would submit that, as with the defence, that it's important that the trial can continue, particularly if the defence for Yang Sari, or Yang Sari himself, has allowed for his defence to be conducted in his absence at the hospital, but through his counsel. In saying that, of course, he's saying that his rights are being protected and the trial can move forward. In relation to the numbers of witnesses that the Yang Sari defence have put forward, in which Yang Sari is happy to have before this court in his absence, the numbers we got to is, as the defence said, it's about 20 witnesses that were on the prosecution's list in relation to the first forced transfer and the second forced transfer. In addition to that, they've also, or Yang Sari has waived his right to 2 further witnesses, witness 389 and witness 126, and we note a further witness 186, which has waived his right to be present at, but the Chamber has noted he's currently unavailable. So, in addition to that, Yang Sari himself is happy to be defended by his defence in his absence in relation, as Your Honours have mentioned earlier, to the documentary hearing next week, the administration and communication structures. If my memory of the communications are correct, which I think they are, he has also waived his right to the other document presentations, and the ones I'm referring to in relation to military structure and communication, policies, and also certainly the corroborative evidence debate about whether or not statements, how many statements and what should be admitted before this court without witnesses testifying. So I think when Defence Counsel Mr. Carnivus said last week that there's enough business to not delay this trial at all, pending the situation with Mr. Yang Sari. There's enough business to be conducted until Christmas. Our calculations are that is correct. I just received a document from the Chamber. It was issued just a couple of minutes ago, and we would need to take a little bit more of a moment to review it. But certainly from the list of the preliminary indications of individuals that Your Honours intend to hear in relation to the forced movement of this trial, it would appear a significant number of the witnesses that the prosecution put forward, Your Honours have now decided to call in this trial. And we also note a number of witnesses that the lead co-lawyers have put forward, and Your Honours would like to hear in relation to the forced evacuations. And obviously, time will tell, but I think the situation with the Yang Sari defence team, on the basis of their cooperative approach in relation to witnesses that don't directly give evidence against the acts and conduct of Yang Sari, it may well be highly likely that these other witnesses that were proposed by the lead co-lawyers would fall in the same category. And certainly from the numbers here, there would be enough witnesses to hear up until and probably shortly beyond the Christmas period. So that's a period of a couple of months. Your Honours, we certainly understand your concern. It's a concern of all of us in terms of planning of this case. It's one thing to say that to have waivers, but then another thing to pull them away the night before. And I think, as Mr. Carnivus has mentioned, the situation with the witness that will be attending tomorrow was one which they didn't foresee and the prosecution didn't foresee. It was a prior statement taken from another organisation which had some information in it about Yang Sari in the post-79 period. And it was only late notice that arrived. And then on reviewing it, we made the indication, certainly from the prosecution perspective, that the type of information that was in that statement in relation to Yang Sari after 1979 was not, in our view, and we're not saying that everything after 1979 isn't relevant, but in our view wasn't particularly relevant, and so we wouldn't be asking questions of the particular witness. And on hearing that, the Yang Sari defence team immediately reinstated their waiver, showing good faith in that process. I think, as Mr. Carnivus has said, I think that the situation of, in relation to the forced transfer witnesses, the first and the second phase, the situation of waivers being given, which they have in large part, and we'll have to marry it up with your Honour's list, of being revoked, as Mr. Carnivus has said, I think it's highly unlikely because these witnesses, as Your Honour is aware, have been selected and placed in that part of the case that relates to the largely the crime itself, the crime of what we're alleging of the transfer of the population, but not centrally in relation to the acts and conduct of the accused. So we would find that it would be unlikely that any, if not unlikely, only a few witnesses may present themselves in that manner. And Mr. Carnivus also raised the discussion that we had earlier, and if that situation arose where a witness mentioned some evidence about Yang Sari, and it's certainly not on the record of their statement, so it's nothing that the trial chamber or the parties could have predicted, then there would be a couple of options, of course, and one option would be that witness could be recalled for that 10 minutes or 15 minutes of cross-examination once and assuming Yang Sari gets better. And secondly, if that couldn't happen, that information could be excised from the transcript, so there's no breach of his right. But I think it's important to note that these witnesses have not been selected on the basis they give evidence on the acts and conduct against Mr. Yang Sari. So, Your Honours, our submission would be based on the waivers given by the defence, that we don't think there'll be significant. We don't think there'll be any delay. In fact, the only difference being is that the way that Your Honours had envisaged the case, that the forced transfer witnesses or the movement of the population witnesses would come a bit further down the track, they would have to be brought forward. And it's our submission that that's the situation that we're presented with. And as Your Honours have always advised the parties, we will be flexible and we will move to that part of the case. And then if Yang Sari health improves, then those further witnesses could be brought forward at the end of the movement of the population, where the situation could be reconsidered after Christmas. I have nothing further on.
The President, thank you. The lead co-lawyer for the civil parties, you may proceed.
Oui, merci, Monsieur le Président.
Thank you, Mr. President. I would like to make a few remarks regarding the civil parties. As we said the last time, the civil parties would like the proceedings to move forward as coherently as possible. So we are, of course, in agreement with the idea that we should proceed with witnesses and civil parties concerning forced transfers. We have seen the list proposed by Yang Sari, but I have also discovered that this chamber is putting forward a new list of witnesses and civil parties to be heard in the near future. And I suppose that the Yang Sari defense team will have occasion to make his submissions on that list. And I hope he will do so as quickly as possible so that we may know the witnesses and civil parties who will be heard in the next few weeks and months, because we are mindful of the need to move the proceedings forward. We know that the list before the chamber contains a number of civil parties, so would like to know what the position of the Yang Sari team is regarding that list. And it may well be that we'll have to discuss some issues relating to that list. On behalf of the civil parties, I would like to draw the Chamber's attention to the fact that this situation can only be temporary, because there may be problems that will arise. Yang Sari's defense team and the prosecutor has already referred to some of these problems. For instance, when a witness may have to talk about Yang Sari, or the parties present may also refer to Yang Sari. We, the civil parties, are particularly concerned about the health status of Yang Sari. We want to know how serious his situation is and for how long he will be in that situation. The civil parties do not receive medical reports. We did not receive the last report. We had to discuss that 10 years ago. I'm speaking in abstract terms. Would like the chamber to give us precise information with regard to what Mr. Campbell will decide. Would like to be informed as quickly as possible, because it is fundamental. Because the chamber will have to take important decisions. So, in the coming weeks, it is acceptable that we should hear witnesses and civil parties in the absence of Mr. Yang Sari, but it will be very important for us to know exactly what the situation of Mr. Yang Sari will be.
Judge Cartwright, please proceed.
Thank you, President. Just in response to those submissions from the lead co-lawyers, first, I believe it's already been made clear to the lead co-lawyers that relevant medical material has been placed on the case file and is available to all parties. Secondly, the information that has been provided to Professor Campbell is as I summarised it earlier, except I have been told that the Office of Administration does not yet have the scan from the Khmer Soviet Friendship Hospital, and we are asking the administration to ensure that urgency is given to that. Thirdly, the medical assessments have been made available to the parties as and when appropriate and relevant to those parties, and I anticipate that the Chamber will continue to do that. In short, the civil parties are not being deprived of information that other parties do not have. Thank you, President.
Thank you, Judge Cartwright. Judge Lavange, please proceed.
Thank you, Mr. President. I'd like to ask the Ieng Sary defence a question. Prior to that, I would thank them for the useful information they've provided this hearing this afternoon. But it is important for the Chamber to know precisely what the scope is of the waivers to which Mr. Ieng Sary has consented. When you hear a witness, you hear a certain number of questions being put to that witness, and the Chamber has to decide if such questions are relevant, and that is the standard that is applied, the relevance of the question vis-à-vis the scope of case 002. If I take the case of a witness who will be heard as of tomorrow, that witness is supposed to testify on military structures, but that witness may possess relatively important information on a certain number of other points which concern case 002/1. And so my question is this: is the waiver conditional, and if so, to what extent? And we need to understand this because we do need a certain foundation to be able to establish an agenda and a program for hearing all of these witnesses. I hope that question was clear to you. Thank you.
Thank you, Judge Laverne. Let me just explain the process that we went through in going through the list, and then also going over them with our client in order to secure the waiver. We looked at the witnesses, we looked at their statements, we looked at the documents that are associated to the witness. We went through parts of the case file to see what, if anything, might be used with respect to these witnesses. And where we were of the opinion that there may be something that Ms. Ieng Sary would definitely need to be present to give us further advice, we advised against the waiver, leaving it, of course, up to him. Recognizing also that almost every witness is going to come here and say, we think, or we know, or we were told that the leaders did this, the upper echelon did that. These are buzzwords that are often heard in this courtroom, which one could say touch upon Ms. Ieng Sary one way or the other, but we have to be realistic. And in our consultation with Mr. Ieng Sary, we went through the names, we went through the summaries that were prepared by the prosecution, as far as what they believe they would be, the evidence they would be giving, or the civil parties, for instance. We had a discussion concerning his knowledge of the individual and whether that individual had any particular information pro or against Mr. Ingsari. And based on that, we provided advice, and he gave us his instructions and the waiver. It is our understanding that all of these witnesses are going to come in and testify to the full extent that the trial chamber deems their testimony necessary. So whether something is relevant or not relevant, that's a discretionary issue that is up to the judges. But we do recognize from looking at the witnesses where the relevance of a witness's testimony would be. Now, if something unexpected were to come up, obviously that's where we have reached this understanding with the prosecution that rather than hold up the entire event and that we could hear the witness on that issue and then bring the witness back if necessary after we've had an opportunity to consult with Mr. Ingsari. We don't anticipate that happening, at least not on a regular basis. It may happen here or there, but I doubt very seriously. But I don't think, as far as I'm concerned, and as far as my understanding and my advice to Mr. Ingsari was that this waiver, barring that one caveat, is to allow the parties to examine the witness to the full extent for which the witness is being brought here. So that's our position. And that's why we're taking a very strict position with respect to witnesses that we're saying we're not waiving. In those instances, we are not waiving. Full stop. Here, we're trying to accommodate to the extent possible. A lot of these witnesses are what we would call them in other courts crime-based witnesses. They're necessary for a variety of reasons. You have civil parties as well. And Ms. Ingsari knowingly, intelligently, and voluntarily has issued his waiver. And that's why we went over these names, the last 15 names, on 3 different occasions with him to make sure that he fully understood what it was. I don't know if I'm answering your question. I'm trying.
Just one clarification, if I may. Questions, of course, will be asked by the parties, but also by the judges, because we have a mixed system here, where the judges also ask questions, as you are aware, and I understand that your client has accepted to have a witness heard in as complete a way as possible to the extent that the questions are relevant, and of course you would request to have the witness back at a later stage if that had to be necessary to guarantee the defense rights of your client. Is my understanding correct? Yes, and I do fully appreciate the fact that judges can and do, in fact, ask questions in the system, and as they do at the other international tribunals. So I don't. We obviously factor that in, and especially when a judge can ask questions beyond what may be apparently areas of relevancy. They can go to other areas. We fully understand that. If a situation were to come up where I was under the impression, or Mr. Angodom, I should say we, as opposed to I, if we were under the impression that somehow our client's rights were being compromised, I can assure you, as day follows night, that I will be the first on my feet to raise an objection. I don't think that shyness is one of my qualities, in court at least. Thank you. very final clarification. Tomorrow we are going to be hearing TCW 428. What is the precise position of the Yang Sari defense for this witness? Does it accept to have the witness heard on every relevant subject concerning case 002/1, or do you feel that we can only hear the witness on issues relating to the military structure?
No, the witness 4002/01. I think that's the case with every witness. That is the case with every witness that the Mr. Ng has waived. Let me repeat. It is my understanding that these witnesses that we have waived are for the purpose of 002/01. That's how we looked at it. I think I'm being clear on that point. If there are no more further questions, then I'll be seated. Thank you.
Thank you, Counsel. President, thank you for all the remarks and observations made by all the parties. Regarding the possibility of the upcoming proceedings, as it is related to the challenge of the health of the accused Yang Sari, who is being treated at the hospital. And in particular, the bench is grateful to the clarification and confirmation by the Defense Counsel for Yang Sari, Michael Canavast, in his response to the questions put to him by judges of the bench. As the Chamber informed, in order to facilitate the agenda for the upcoming hearings, as well as to further clarify the facts alleged against the three accused within the scope of the proceedings, in case 002/01, in the third segment, as the Chamber determined pursuant to Rule 89.1 bis, the Chamber will assign the greffiers of the trial chamber to read the facts alleged against the accused as indicated in the closing order in the document A121/7.2. Those are the remaining facts to be read out. And as for the closing order, the portion of the paragraphs to be read out where it is redacted, that is for the purpose of the protection of the witnesses. Ms. Sakolbuti, you are now instructed to read portions of the closing orders starting from 118 to 149, 156 to 165, 221 to 227. You may proceed. Section 5, Military Structure, Establishment of the Revolutionary Army of Cambodia, Paragraph 113. The Revolutionary Army of Cambodia, the RAK, was a core institution within the CPK governed Democratic Cambodia. CPK policy relied heavily on the implementation of its goals by forceful means, making the military an important part of its government apparatus. From the outset, the CPK considered that for self-defense and self-liberation, it is imperative to use violence, whether political violence or armed violence. It is imperative that the people be armed, that is, there must be an army in order to defend the people, to defend the revolution, and to go on the offensive to counterattack the enemy. Paragraph 114. The CPK asserted that its armed forces originated in a secret defense unit. By 1968, these forces had been upgraded into the armed guerrilla units. 17 January 1968 marks the official launch of an armed struggle and the birth of the CPK Revolutionary Army. According to the official line of the party, by 1969, the preconditions for an army were already there. In some locations in the major zones, there were already companies, many units, platoons, squads, teams. Other locations had just platoons, squads, and teams. However, those forces were the ranks of a revolutionary army. In March 1970, the latter was officially designated as the Cambodian People's National Liberation Armed Forces, or the CPNLAF. Paragraph 115. The formal reorganization of the armed forces was proclaimed in July 1975 at a gathering that was officially described as an important political conference of the CPK Center for approximately 3,000 representatives of every unit of the Revolutionary Army, which was addressed by the Comrade Chairman of the High-Level Military Committee of the party. RAK received expert assistance and military equipment from other countries, most prominently from China. B. Role of RAK. Paragraph 116. The role of the RAK is defined in two central documents on the organization of Democratic Cambodia. Article 19 of the Constitution of Democratic Cambodia describes the true goals of the Revolutionary Army of Cambodia, the RAK, defend the state power of the Cambodian people, and at the same time help to build a country. According to Article 27 of the Communist Party of Cambodia Statute, the RAK was responsible for both external and internal security, as well as generally participating in building the country. This understanding of the RAK's role was repeated and reiterated in various CPK publications and party committee meetings. Paragraph 117. External security or national defense was the core task of the RAK, in particular in the context of the armed conflict with the SRV and in relation to border disputes. Internal security comprised of the defense of the CPK rule against perceived enemies and spies within the armed forces, the party and the country as a whole. Paragraph 118. With the term building the country, the party imposed upon the RAK a responsibility for furthering prosperity and increasing the people's living standards, and also committing the armed forces to strive for the achievement of the 4 years plan's goal of a rice paddy yield of the 3 tons per hectare. In addition, each military unit was supposed to support itself, with the exception of the troops at the border. CPK Central Military Organs, Military Committee of the Central Committee. Paragraph 119. The Military Committee, or High-Level Military Committee, was a CPK Central Committee organ set up since at least 1970, and the existence of which was reaffirmed at the 4th Party Congress. In line with the original functions of the CPK's armed forces, combining security with purely military tasks, the Military Committee has also been described as the Security Committee or Military and Security Committee. Also attached to the Central Committee were assistants with military responsibilities. Paragraph 120. The Military Committee acted as an organ of the party center and thus ensured control of the RAK by the party center. The Central Committee and the Military Committee sometimes met in joint session to decide on military matters, effecting a unified strategic command over the armed forces. Paragraph 121. Ieng Sary claims that the Military and Security Committee was comprised of Pol Pot, Nuon Chea, and Son Sen. Other members of the Military Committee included Sao Pham and Tam Mok, although they may have had less formal responsibility. Witnesses also named Won Vet and Kai Pok as members of the Military Committee. After 17 April 1975, Pol Pot continued to chair the Military Committee. Although Nuon Chea recognized that such an organ existed during the CPK era, he denies being a part of it. Several witnesses, however, including Ieng Sary, mentioned him as a member of the committee. Paragraph 122. The Military and Security Committee decided on military and security matters, including killing, operation of S-21, other secret locations, secret agents, and general matters. Ieng Sary states that this committee reported to the Standing Committee after receiving reports from the zones, and that he personally heard reports on security. Paragraph 123. Apparently, in connection with their positions on the Military Committee, Pol Pot, Nuon Chea, and Son Sen were in overall charge of S-21 and the security policy in general. Son Sen frequently met and coordinated with the other members of the Standing Committee, ensuring that the CPK leadership had constant knowledge and control over RAK activities. General Staff, paragraph 124. The central body of the RAK was the General Staff. During a CPK Standing Committee meeting on 9 October 1975, Son Sen was designated as responsible for general staff and security, while Pol Pot was assigned the general responsibility over the military. Son Sen subsequently headed the general staff. Reports were submitted to him and he issued orders. Paragraph 125. The general staff was assigned with the command and administration of the armed forces. It centrally coordinated various tasks, such as the setting up of divisions, organization matters, intelligence, military installations, policy, logistics, weapons, ammunition, food supplies, uniforms, transport, and medicine, and issued movement orders to the divisions. The General Staff also removed secretaries and other cadre at center divisions, while appointments to leading positions in the center divisions were made in the name of the Central Committee or by Pol Pot, Nuon Chea, Ieng Sary, and Son Sen. To implement the party's line and policy, the General Staff organized study sessions for selected cadre, as well as regular meetings of the leaders of the center divisions and independent regiments for reporting and issuing orders on various matters. Composition of the RAK. Paragraph 1 through 6. Article 19 of the Constitution of Democratic Cambodia describes three branches of the RAK: regular, regional, and guerrilla forces. All of these three categories were under the absolute leadership monopoly of the Communist Party of Cambodia. The Revolutionary Armed Forces, including the regular army of the center and all local military units, which were all ultimately under the command of the Central Committee and its military committee. Similar to other state organs, the Revolutionary Army was described as the pure dictatorial instrument of the party. The regular army, paragraph 1 through 7. The regular army was composed of divisions and independent regiments. Divisions were separated into center divisions, reporting directly to the center, and regional divisions. In most cases, a division consisted of 3 regiments, each regiment of 3 battalions, and each battalion of 3 companies. Center divisions, paragraph 1 to 8. The center divisions were commanded directly by the center, as were the independent regiments. They constituted the main military force of the RAK, and as such, carried out the bulk of the military operations against the external enemies. Paragraph 1 to 9. Center divisions were frequently redesignated, dissolved, or merged into each other during the CPK era. As of March 1977, the center forces included divisions 801, 703, 310, 450, 170, 290, 502, 920, and 164, and independent regiments 152, 377, and 488. Paragraph 130. The RAK also established 2 combined field commands that each exercised command over several divisions. Both were established in the East Zone. The first of these field commands was located on Route number 1 in Sector 23. It was commanded by Son Sen and comprised of Divisions 703, 340, 221, 460, and 805, 210, 230, 250, and 270. The 2nd Field Command was located on Route 7, also in the East Zone. It included Division 207, ex-Division 310, Division 603, ex-Division 450, Division 280, and Division 175, plus elements of Division 502 and forces of the Central Zone, former North Zone. Originally, Route 7 Field Command was commanded by Sao Pham with Gai Po as deputy. Sao Pham was replaced by Son Sen after the purge and suicide of Sao Pham. Paragraph 131. Center divisions were severely purged, which led to their subsequent redesignation or merging into other divisions. Notably, Divisions 310, 450, and 920 were purged as part of the purges in the North Zone, from where these units originated. As a result of this purge process, Division 310 and Division 450 were redesignated Division 207 and 603 respectively. Paragraph 132. Reorganization of divisions also occurred due to the intensification of the armed conflict with Vietnam from late 1977, which was accompanied by the creation of a number of new center divisions formed out of an expansion and reorganization of units originating in the Southwest Zone. These included Divisions 340, 221, 440, 460, 210, 230, 250, and 270. Zoned armies. Paragraph 133. The 2nd primary branch. President. Thank you, Mrs. Sakobuti. President. Today, proceeding has come to a conclusion We will adjourn the proceeding today and resume tomorrow. That is the Wednesday, the 3rd October 2012, starting from 9 a.m. For tomorrow's proceeding, the Chamber will continue to hear the readout of the portion of the closing orders as part of the case 002/01, which are the facts in the third segment of the proceeding in this case. And then we will hear the testimony of the witness TCW 428. In fact, the witness was here today as a reserve witness, and due to the time arrangement, he will appear again tomorrow. Security guards, you are instructed to take the accused Nuji and Kyo Sampon to the detention facility and bring them back to the courtroom tomorrow morning before 9 a.m. The hearing is now adjourned.
សូមអញ្ជើញក្រោកឈរ